Hey y'all, it's Kim. So this is it's basically an appeals court document disclosure. Um Somebody had filed a lawsuit to get some documents disclosed of the Epstein or even the Maxwell Giuffre case. And so anyway, there's like 2,000 pages of stuff. Some of them may repeat. I'm not sure. This is something I found on the document cloud service where they've got so many documents for Epstein, like hundreds of thousands of pages, I think. But anyway, we're going to start right here. This is page 66 of 2024. This is number 33. So we're going to start here. It says, in none of the nine instances where was there any publication of the entire January 2015 doc or statement? See Exhibit H at 7-8, and then Exhibit I at 4. Miss Maxwell and her agents exercise no control over authority over any media organization, including the media identified in plaintiff's response to interrogatory number 6 in connection with the media's publication of portions of the January 2015 statement, Exhibit J at 24, and then Exhibit K 2 through 3. Plaintiff's defamation action against Ms. Maxwell, which would be Giuffre, 8 years after Epstein's guilty plea. Plaintiff brought this action, repeating many of the allegations she made in her CVRA joinder motion. The complaint alleged that the January 2015 statement contained the following deliberate falsehoods: that Giuffre's sworn allegations against Ghislaine Maxwell are untrue, that the allegations have been shown to be untrue, and that Giuffre's claims are obvious lies. And then document 1 at 30, boldface and underscoring omitted. A summary judgment standard. Courts should not be reluctant to grant summary judgment in appropriate cases. One of the principal purposes of the summary judgment rule is to isolate and dispose of factually unsupportable claims, thereby permitting courts to avoid protracted, expensive, and harassing trials. Don King Products Inc. versus Douglas. And then here's a bunch more case law on that. Colt Celotex Corp versus Catre, I don't know. And Mary versus Dakin, where summary judgment is sought under Article 1, Section 8 of the New York Constitution, the New York Court of Appeals has declared, we reaffirm our regard for the particular value of summary judgment where appropriate in libel cases. So Amino AG versus Moore Jankowski, particularly when as here, a defendant is challenging a defamation claim under the independent state law approach articulated in Immuno AG that might make summary disposition more likely than under a federal approach. See identification. I don't know what that ID means. Summary judgment is appropriate where there is no genuine issue as to any material fact, and the moving party is entitled to a judgment as a matter of law. Something about federal something, civil, blah, 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 whatever. The relevant inquiry on application for summary judgment is whether the evidence presents a sufficient disagreement to require submission to a jury, or whether it is so one-sided that one party must prevail as a matter of law. Anderson versus Liberty Lobby, Inc. Their mere existence of some alleged factual dispute between the parties will not defeat an otherwise properly supported motion for summary judgment. The requirement is that there be no genuine issue of material fact. The substantial law determines what facts are material. Only disputes over facts that might affect the outcome of the suit under the governing law will properly preclude the entry of summary judgment. Factual disputes that are irrelevant or unnecessary will not be counted. A dispute about a material fact is genuine if the evidence is such that a reasonable jury could return a verdict for the non-moving party. In the face of a properly supported summary judgment motion, the plaintiff may not rest on the allegations in her complaint. The trials court function is to determine whether there is genuine issue for trial, and there is no reason for trial unless there is sufficient evidence favoring the non-moving party for a jury to return a verdict for that party. The plain language of Rule 56C mandates the entry of summary judgment against a party who fails to make a showing sufficient to establish the existence of an element essential to that party's case and on which that party will bear the burden of proof at trial. Celotex Court versus Catret. In such a situation, there can be no genuine issue as to any material fact, since a complete failure of proof concerning an essential element of the non-moving party's case necessarily renders all other facts immaterial. The moving party is entitled to a judgment as a matter of law because the non-moving party has failed to make a sufficient showing on an essential element of her case with respect to which she has the burden of proof. And then advisory committees knows 2010 amendments, whatever, restoration of shall grant summary judgment was intended to express the direction to grant summary judgment and avoids the unintended consequences of any other word. Argument: Ms. Maxwell is not liable for republications of her January 2015 statement that she did not authorize a request or by entities she did not control. Summary judgment is warranted to the extent plaintiff seeks to impose liability on any media's republication of all or a portion of the January 2015 statement. Messrs. Barden and Gow, acting on behalf of Ms. Maxwell, caused the January 2015 statement to be transmitted, published to various individuals employed by media organization. The question presented in this argument, one, is whether Ms. Maxwell is liable for any republication of all or a portion of the January 2015 statement by the media. Under New York law, the answer is no. Liability for republication must be based on real authority to influence the final product. Davis versus Costa and Gavras, something. Where a defendant had no actual part in composing or publishing, he cannot be held liable without disregarding the settled rule of law that no man is bound for the tortious act of another over whom he has not a master's power of control. Falwell versus Miller, and then Garassi versus Probst, holding that defendant was not liable for republication in part because there's no indication that Probst had any control over whether or not Newsday published the article. Conclusive evidence of lack of actual authority is sufficiently dispositive that the trial court has no option but to dismiss the case. And then Rinaldi versus Viking Penguin, Inc. As the New York Court of Appeals held in Garassi, it is too well settled to be now questioned that one who prints and publishes a libel is not responsible for its voluntary and unjustifiable repetition without his authority or request by others over whom he has no control and who thereby make themselves liable to the person injured, and that such repetition cannot be considered in law a necessary, natural, and probable consequence of the original slander or libel. 938 NE 2D at 921, internal quotations and citation omitted. The rationale behind this rule is that each person who repeats the defamatory statement is responsible for the resulting damages. With the goal of garnering maximum publicity and defaming Miss Maxwell, Miss Giuffre filed an entirely unnecessarily joinder motion with lurid details about sexual acts for the purpose of attracting the attention of the public, which was curious, titillated, or intrigued about alleged sexual acts and relationships among the rich and famous. In defense of Miss Maxwell's reputation, Messrs. Barden and Gow responded with the January 2015 statement. The email transmitting the statement explained it was a quotable statement on behalf of Miss Maxwell, and no further communication will be provided by her on this matter. Exhibit F, emphasis applied. The media representatives were notified that if they intended to use this statement, it was to be quoted in its entirety. See this motion at 24 at 8. Miss Maxwell and Messrs. Barden and Gow had no ability to control whether or how the media recipients would use the statement, and they made no effort to control whether or how they would use the statement. Exhibit K 2 through 3, and then Exhibit J 24. Ms. Maxwell is not responsible for any republication of the January 2015 statement, whether it was republished in whole or in part, since she had no authority or control over any media that published any portion of it. In the words of this court, she has no real authority to influence the final product. And then Davis 588 F, I guess, supported at 1096. The media's selective partial republication of the statement is more problematic yet. An original publisher of a statement cannot be charged with the republisher's editing and excerpting of her statement. So Rand versus New York Times Company. The rule applies with even greater force, whereas here a defamation claim is grounded on the expression of opinion. An individual cannot be liable for the republication of a derogatory but constitutionally protected opinion when the foundation upon which that opinion is based is omitted. The defamatory remark should be read against the background of its issuance. And then Mincher versus Chesley, and then citing James versus Gannett Company. Okay, the rationale for this rule is found in the New York Court of Appeals explanation of how an original publisher's alleged defamatory statement should be interpreted. The statement complained of will be read against the background of its issuance with respect to the circumstances of its publication. It is the duty of the court in an action for libel to understand the publication in the same manner that others would naturally do. The construction which it behooves a court of justice to put on a publication which is alleged to be libelous is to be derived as well from the expressions used as from the whole scope and apparent object of the writer. And then James 353, NE 2D at 838, emphasis applied, citations and internal quotations omitted. The January 2015 statement was intended to be read by the media recipients in its entirety. One, it was intended to be a comprehensive, one-time only response to all plaintiffs' lurid and false allegations of sexual and other misconduct by Miss Maxwell. Let's see Exhibit J13. Two, the statement was complex and that it could not be quoted partially and out of context and still convey the intended meaning. Among other things, this statement was intended to show why a plaintiff could not be believed, why her allegations are obvious lies, by pointing out how her story changed each time she retold the story. As Mr. Barton explains, selective and partial quotation and use of the statement would serve my purposes. It was intended to address plaintiff's behavior and allegations against Miss Maxwell on a broad scale. That is to say, plaintiff's history of making false allegations and innuendo to the media against Miss Maxwell. This is why the statement references plaintiff's original allegations and points out that her story changes, i.e., is embellished over time, including the allegations now that Professor Dershowitz allegedly has sexual relations with her. This is why I distinguished in the statement between plaintiff's original allegations and her new joinder motion allegations, which differed substantially from the original allegations. And this is why I wrote, each time the story is retold, it changes, with new salacious details about public figures and world leaders, and now it is alleged by plaintiff that Alan Dershowitz is involved in having sexual relations with her, which he denies, emphasis applied, and then having established the dramatic difference between plaintiff's two sets of allegations, which suggested she was fabricating more and more salacious allegations as she had more time to manufacture them. I added the third paragraph. Ms. Giuffre's claims are obvious lies and should be treated as such and not publicized as news as they are defamatory. Believe then, and I believe now, that it was and remains a fair inference and conclusion that her claims were and are obvious lies, as noted, her claims not to have slept, as noted, her claims not to have slept with Prince Andrew and to have slept with Prince Andrew are a classic example of an obvious lie. One or other account is on the face of it a lie. Exhibit J20, that Mr. Barton, on behalf of Ms. Maxwell, expressing his opinion in the form of a legal argument as a lawyer will be lost if words and phrases are extracted from and used outside the context of the January 2015 statement. Yet this is precisely what the media did in their articles on the statement and what plaintiff did in her complaints. Finally, the statement was intended to be a shot across the bow of the media recipients so that they understand the seriousness with which Ms. Maxwell considered the publication of plaintiff's obviously false allegations and the legal indefensibility of their own conduct. See something 17, and then selectively excerpting from the statement would seriously undermine the purpose by changing the force of the message to the media recipients. Under these circumstances, selective, partial, and out of context republication of Mr. Barton's deliberate and carefully crafted message to the media representatives as a matter of law cannot result in defamation liability for Ms. Maxwell. Accordingly, the court should enter partial summary judgment. Because plaintiff is a limited public figure, imposing liability upon Ms. Maxwell for republication of the January 2015 statement would violate the First Amendment. As this court recognized in Davis, New York Times versus Sullivan, and its progeny, precludes states from imposing liability without fault in actions for defamation, especially by public figures. Something about Gertz and then versus Robert Welch Inc. And then this principle precludes the imposition of liability for republication of an allegedly defamatory statement on a party who had no actual responsibility for the decision to republish. A public figure includes a person who voluntarily injects himself or is drawn into a particular public controversy and thereby becomes a public figure for a limited range of issues. So Gertz and then James. Okay, public figures includes those who have thrust themselves to the forefront of particular public controversies in order to influence the resolution of the issues involved. The evidence that plaintiff is a public figure is overwhelming, particularly in connection with the subject matters and issues addressed by and underlying the January 2015 statement. See this motion 51 to 54. In the case at bar, Ms. Maxwell and her agents had no responsibility for any media organizations to republish the January 2015 statement, and they did not participate in any such decision. See Exhibits J24 and K2 through 3. Liability for republication by media organizations of the January 2015 statement therefore preclude under the First Amendment. Plaintiffs should be barred from introducing into evidence any republication of an excerpt from the January 2015 statement. In Garassi, the plaintiff suggested in a letter to the Long Island Fire District, where a defendant was a commissioner, The defendant had engaged in self-dealing in the district's purchase of fire trucks. At trial, the plaintiff sought to introduce into evidence portions of a Newsday article that republished parts of the defendant's letter. Defense counsel objected, arguing it was inflammatory and prejudicial. Plaintiff's counsel later argued the article was not being offered as a republication, but on the issue of damages to show how far the allegations had circulated. Additionally, plaintiff's counsel argued that the defendant should have reasonably anticipated that this letter to the fire district would be newsworthy. The trial court admitted the article and the appellate division affirmed. The New York Court of Appeals reversed. The risk of admitting such evidence, the court held, is the jury may charge against defendant a separate, distinct libel not pleaded in the complaint by someone else. Contrary to that rule, that the original publisher of a libel is not responsible for its subsequent publication by others, Grassi. And then accordingly, the court held, absent a showing that defendant approved or participated in some other manner in the activities of the third-party republisher, there is no basis for allowing the jury to consider the article containing the republished statement as a measure of plaintiff's damages attributable to defendants. And then Karaduman versus Newsday Inc. And then neither Miss Maxwell nor her agents approved or participated in any activity of any media organization in its decision to publish or to not publish any part of the January 2015 statement, exhibits J2, K2 through 3. Accordingly, there is no basis for allowing the jury to consider any article containing the republished statement as a measure of plaintiff's damages attributable to Miss Maxwell. Plaintiff should be barred from introducing any evidence of any republications of the January 2015 statement by any non-party, Soley versus Wasserman, and then precluding plaintiff from adducing evidence intended to establish claim on which court had entered partial summary judgment. Summary judgment is warranted under the New York Constitution. The January 2015 statement constitutes non-actionable opinion. Whether particular words are defamatory presents a legal question to be resolved by the court in the first instance. Germain versus M&T Bank Corp. And then Sell versus Filipino Reporters Enters Inc. And then Aronson versus Wiersma, and then Wiersma, and then New York defamation law applies. And then it is a settled rule that expression of an opinion, false or not, libelous or not, are constitutionally protected and may not be the subject of private damage actions. Steinhilber versus Alphonse. And then whether a challenge statement is fact or opinion is a question of law to be decided by the court. Enigma Software Group, USA LLC versus Bleeping Company or Computer LLC. And then according to Steinhilber, in Immuno AG versus Moore Jankowski, the New York Court of Appeals declared that the New York Constitution provides greater protection to opinion than the First Amendment of the United States Constitution. The court recognized that in Milkovich versus Lorraine Journal Company, the United States Supreme Court reversed a state court decision dismissing a complaint on the ground that the allegedly defamatory statement was non-actionable opinion. The Supreme Court held there is no wholesale defamation exemption protecting opinion. The First Amendment analysis under Milkovich, the New York court observed, was one-dimensional. The trial court should look first to the allegedly defamatory statements specific words as commonly understood, and then determine whether the statements were verifiable. If the statements were verifiable, then they were actionable statements of fact. See Immuno AG. And then the Supreme Court's holding made it clear that it would not consider as part of the First Amendment analysis the full context of the article in which the challenged statements appear in the broader social context or setting surrounding the communication. Okay, so I'm going to stop here and then probably just keep on going from page 76. But anyway, I'll talk to you later. Have a good one. Bye.